Well, hello and happy Saturday afternoon to everyone. If you've been watching my videos, regardless whether it be on TikTok or else on YouTube, you will note, please, my videos talk about a contradiction between a statutory law here in South Carolina and the South Carolina Constitution. In fact, I have shown up front images of the South Carolina Constitution right here. As I said, South Carolina Constitution right there. This South Carolina Constitution right here that I have pertains to the age of consent, and also the state statutory code right there, copied straight from a book. Now, if I could please, so far I had sent to news at WSPA.com. WSPA happens to be News Channel 7 in Spartanburg, South Carolina. I have called them. I've even sent them emails. I have sent emails to South Carolina State Senator Carl Allen, South Carolina House Member Wendell Jones. I've even notified friends at Fox News up in New York. I've even notified ABC News. I have notified others as well. I've not yet gotten no such response. My argument about the contradiction is that the statutory law cannot stand. Now, there are those who will argue and try to say, well, if a person pleads guilty to statutory law, then of course the Constitution does not apply. I disagree, and here's why. I've actually now got case laws backing up everything. For example, it says here, and I quote, "A guilty plea does not waive the right to contest the constitutionality of the statute that is the basis for a conviction." This is cited under the case law Gesicki v. Oswald, cited as 336 Federal 2nd 371, affirmed in 406 U.S. 913 92, Supreme Court 1773, 32 Limited Edition 2nd 113 1972. In addition, underneath South Carolina 1939, jurisdiction of the subject matter cannot be waived by any act of admission by the parties. In pointing out the difference between jurisdiction of the subject matter and the person, see Chief Justice McIver in City of Florence v. Berry, cited as 61 South Carolina 237, 39 Southeastern 389. Excuse me. If any of you remember history back during, and of course after the, shall say, Revolutionary War, Alexander Hamilton, his face appears on the $10 bill. In the Federal number 78, Alexander Hamilton stated that no legislative act, therefore contrary to the Constitution, can be valid. To deny this would be to affirm that the deputy is greater than its principal, that the servant is above its master, that the representatives of the people are superior to the people themselves, that men acting by virtue of powers may do not only what their powers do not authorize, but what they forbid. A constitution is, in fact, and must be regarded by the judges as a fundamental law. It therefore belongs to them to ascertain its meaning, as well as the meaning of any particular act proceeding from the legislative body. If there should happen to be an irreconcilable variance between the two, that which has the superior obligation and the validity ought, of course, to be preferred. Or, in other words, the Constitution ought to be preferred to the statutes. In fact, for the record, ladies and gentlemen, the framers of the Constitution made it the supreme law of the land. That's talking about United States Constitution. But they left unanswered the question of who was to sustain the supremacy. In the Philadelphia Convention debates of 1787, James Madison, the father of the Constitution, declared that a law violating a constitution established by the people themselves would be considered by the judges as null and void. I'm sure everyone watching this video understands that. Accordingly, James Wilson, Oliver Ellsworth, and John Marshall, all destined for appointment to the U.S. Supreme Court, subscribed to the doctrine of judicial review in their respective ratifying conventions. On January 17, 1788, Oliver Ellsworth of Connecticut declared, he said, and I quote, "If the United States go beyond their powers, if they make a law which the Constitution does not authorize, it is void, and the judicial power, the national judges, who, to secure their impartiality, are to be made independent, will declare it to be void." On the other hand, if the states go beyond their limits, now we're talking about South Carolina right here. If the states go beyond their limits, if they make a law which is an usurpation, which means to undermine, if they make a law which is an usurpation upon the general government, that is the Constitution, the law is void, and upright independent judges will declare it so. In State versus Gaster, this side is 564 Southeastern 2nd, 87, 93, 2002. The law since 1895 under the South Carolina Constitution empowers young women to consent to sexual intercourse at the age of 14. Surely, South Carolina Code Annex Section 16-3-655, subsection B2, 1976, and South Carolina Constitution Article 3, Section 33 represent a contradiction so critical as to deprive the trial court of subject matter jurisdiction in this case. Williams versus State, cited as 410 Southeastern 2nd, 563. So therefore, ladies and gentlemen, I now happen to have case laws backing up what I've been arguing the whole time. Thank you and have a blessed day.